Welcome back everyone, you are watching What the Book KJ, and today I'm going to review a book called The Authority of the Court and the Peril of Politics by Justice Breyer. Justice Breyer wrote this book because he felt that the American public started to believe very vehemently that the Supreme Court of the United States was increasingly becoming an institute which was becoming more and more political. And this is the book where he has tried to warn the public and the other American institutions of what perils are there if there is this widespread belief that the American Supreme Court is just a political tool to secure political wins and not to establish the rule of law. Justice Stephen Breyer is an associate Supreme Court judge of the Supreme Court of the United States, and the judges of the American Supreme Court hold their office during their lifetime, and they can choose to resign, before death if they wish to, and that's what he also has chosen to do. He will retire at the end of this term, and that also brought, makes for a chance for us to revisit what he believes about the institution of the Supreme Court of America and also the America in general. And this book also leaves a lot of messages for Indian judiciary to venture very carefully and not to be seen as a political institute. Day in and day out, we see that various people, they accuse Indian Supreme Court as well, the judges on the Indian Supreme Court, of favoring particular political ideology over another, and sometimes even of being corrupt. So this is the book that talks about the perils of politicizing a Supreme Court. Now there are 3 chapters in the book. The first chapter is called The Court's Power in General. This chapter talks about from where the Supreme Courts in the world derive their power. Most of these courts derive their power through the constitution of those nations. So even in the United States, the Constitution of United States provides for a Supreme Court which has been tasked with interpreting the laws and protecting the freedoms of the citizens. Then he also talks about why is it that the public should obey whatever the court says, because ultimately these are just 9 people who sit there and their orders look like dictates from the kings, which should be followed at every instance, because it follows an assumption that these people know exactly what to do, and these are the people who are guide and philosopher in every situation which is very difficult, and they should guide the nation to come out of it. So he talks about a theory. He says that there are 3 beliefs under which a citizen will obey what the court says. First is that they will be punished if they don't follow it. So he says that the American Supreme Court has no such powers, that if somebody does not follow its decisions, then they will be punished. Even there have been so many instances, and we will discuss in detail as the video goes along, that sometimes even the presidents of the United States have refused to follow the rulings of the American Supreme Court. Then he says that the second thing that may convince a person to follow the dictates of the American Supreme Court may be this thing that they may be rewarded. But he says that again, just as we can't punish someone for not following our rulings, we can't reward anyone for following our rulings. Then he talks about the third thing that really makes a difference, and that's why the American public really follows what the American Supreme Court says. He says it is this fervent belief among the people that whatever the court says is just and is the best for the country, and they know that what they are doing is correct. Then he talks about some of the other political things that come up every now and again when there is a majority of one side, and the majority then shifts to the other side, liberal versus conservative. Even when President Biden got elected, there were so many people who were advising him that because there is this conservative majority in the United States Supreme Court, you should maybe increase the number of judges on the court and pack the court with liberals. so that you can govern unhindered. He warns against such perils, because then he says that people would start to believe that it is a mere political institution which can be just herded around anywhere by the Congress. Because you see, if you can plan the outcomes of decision by just ensuring that there are a certain number of judges on the court, it certainly impacts the impartiality of the court, and also impacts its efforts to enforce rule of law in the country. Then he talks about a very important case which he discusses throughout the book. In Brown versus Board of Education 1954 case, it was ruled that there has to be racial integration of all schools in the whole country. Earlier, what used to happen was this, that there was racial disintegration or racial segregation, wherein black kids study differently in different institutions and white kids studied in different institutions. And the Supreme Court ruled that there has to be integration of schools, and there has to be commingling of white and black kids. But the governor of that state did not agree with the ruling and did not implement it. Then, then it came upon the president to act, because it is his duty to ensure that the Supreme Court's ruling are implemented. What he did, he talked with the Attorney General, and the Attorney General told to him that it is his duty to ensure that the rule of law prevails, and what is rule of law is decided by the Supreme Court. So the president sent in 1,000 troops, and these troops belonged to a contingent which was very famous, and they had also won so many wars and ensured that they had made a name for themselves. So in that sense, they were considered very patriotic by the people of the country. So he sent in those troops, and these 1,000 troops took these 9 black children by hand and ensured that there was integration. But they, could not stay there for long. So after some months, when they left, the district decided to close that school because they wanted to take their stands, and they closed that school down, and nobody got an education thereafter. So in this way, they did not just did something bad for the black children, but also the white children. They destroyed their education for a little while. And then this is the case by which Justice Breyer tries to make this point, that judiciary does not have the power of sword or purse. They have to rely upon the executive to ensure that their rulings are implemented. And this is where he tells that the president has to ensure that the court's rulings are implemented. Then he talks about another very interesting case. It is a relatively recent case of 2000. This case is Bush v. Gore case, famously known as the presidential election case. So what happened was this, that the margin of the win of the presidential candidate was so narrow that it fell upon the Supreme Court to decide who actually won the election. So the Supreme Court ruled that Bush had won the election, and Mr. Al Gore had been defeated. So the people of the United States, everybody was affected by it, that who was to be their next president. They not only accept the ruling very peacefully. Justice Breyer says that this is the habit of the people now, to accept the rulings of the Supreme Court, even if they do not agree with it. And he talks about how people did not come out on streets for violent protests, did not pelt stones, in the public spaces. And this talks about how people have now built trust in the Institute of United States Supreme Court, that they are just, and they are not a bunch of politicians in robes who are going to vote as per their parties that appointed them. In the next chapter, in chapter 2, he talks about the court as a check. Now we all know that this is a democratic principle, that different institutions, even in India, legislature, executive, and the judiciary, they act as a form of check and balances upon each other. There's a very important question that is often asked everywhere in every democracy, and even in India, that who are these unelected judges to judge the actions of elected representatives who sit in such huge numbers in parliaments and make laws, pass laws after such deliberation, and who are these people to judge the constitutionality of these actions? Um, and the answer is quite simple. It's a constitution that gives them this right and this duty to judge the constitutionality of such actions. He talks about how the American Supreme Court mostly interprets laws that are federal in nature, and these are the laws. Mostly, these are the lawsuits that depend upon the interpretation of a particular word in a particular statute. For example, costs. He talks about an example wherein it is held that a particular party will bear the costs for the suit for, say, medical case that has been waged by them. So the Supreme Court has to decide if this cost that has to be borne by the losing party also includes the cost that will be spent by the winning party upon engaging an expert who will give an expert opinion to the court. So he talks about how most of the business that they do in the courts is very, boring, and also depends upon the interpretation of statutes, and it does not really impact a lot of people in so many cases. But then he talks about a lot of 5-4 cases that are decided very vehemently on 5-4 votes. These are split decisions, and they also have very wide-ranging, impacts upon the American democracy. For example, say abortion rights, and also LGBT rights. These are the cases which not just divide the judges on the court, but also the country as a whole. And then he talks about whatever the judges do on the court is interpret, and interpretation is held by very basic principles of interpretation, that is, to look at the text, to look at the history of it, history of why this particular law was enacted at all, and then there are relevant legal traditions that have to be looked at, and the precedents of the court's previous rulings also have to be weighed in to decide the cases. Then there is the statute's purpose for enactment, and at last, consequences. He says that most of the differences in opinion of the judges crop up because of the simple reason that some judges weigh in some factors more than they weigh in others. For example, some judges may weigh in text and the history more. For example, Justice Scalia, who was an originalist, so he weighed in text more as compared to some other judge who may weigh in statutes, purpose and consequences more than its text. For example, if I rule this, what will happen? So this is the consequence of my ruling. Should I rule this or should I rule that? So he says that this is the one of the main reasons that there is difference in the way judges rule, and it is not always based upon the fact that they belong to a certain ideology or they have been appointed by a certain party which may or may not be in power at that point in time. Then he also says that the court mostly tries to stay away from controversial cases, and also tries to not interfere in the domain of executive policy making. He also then talks about how the court has devised this unique thing of ruling upon the implementation of the laws rather than the constitutionality of the law itself. So what this does is to ensure that the president or the Congress can change these orders or these laws to better suit these rulings, and also to avoid a conflict between the institutions of legislature, executive and judiciary. He gives the examples of immigration laws, but he says that the interpretation of the constitutional text is ultimately given by the Supreme Court itself. So when the interpretation of the Constitution comes, the Supreme Court can neither shy away nor can it say something in very uncertain terms. So for example, there is some case on freedom of expression or freedom of press, then the court has to come out very clearly about what it believes is the law and how it has to be dealt with. Then he talks about how court also acts like a border patrol. because the constitution ensures that there is a border between the lives of citizens and the powers that are conferred on the state. So the court is a border patrol that borders, that patrols on the borders to ensure that the court does not get in a lot into the lives of the citizens and do not impinge on their privacy or liberties. Uh, he also talks about how the courts try to avoid overtly political cases. Um, for example, say delimitation exercise, wherein it is ensured, it is ensured that constituencies are fixed so that elections can take place. For now, for example, now in India, J&K is being delimited again. So there is a lot of controversy surrounding that, and every party has something to say about it, and uh, that this is Muslim majority. This used to be Muslim majority constituency. Now you have divided it in such a way that now it is Hindu majority or something like that. So he says that the courts have always tried to stay away from such overtly political cases to ensure that the court's authority is not compromised. Then he also talks about a very interesting case called Korematsu v United States. Uh, this is an interesting case of World War II, where it was actually upheld by an order was upheld wherein the government had ruled that 70,000 US citizens of Japanese descent had to move from West Coast to a camp, and that camp was like a prison because America was in war with Japan, and they doubted, they had suspicion that these people belong to the Japanese descent, and they may, switch loyalties and help the and help Japan during the war. So in during that case, they were, it is something else to ask them to move from one place to another, but to put them into camps that are like prison, like and deprive them of their liberties is something else. So it amounts to something like suspension of fundamental rights. So the author tries to talk about how the the way the Supreme Court now rules and the judicial jurisprudence also has now changed. In that time, he talks about how Justice Black had said that somebody must fight this war. Either it is the president or us, or say the Supreme Court. The Supreme Court cannot fight, so let the president do what he must do during a war. And the Attorney General at that time had also said the Constitution hasn't greatly bothered any wartime president. So he says that the Constitution really doesn't really hasn't bothered any president. So whatever action he takes during a war is legitimate, because his ultimate interest is to protect the nation, the existence of the nation, right? So in that also there were three dissents, and there was a similar case in the UK House of Lords. In that, Lord Atkin's famous dissent, in that he said, the name of the case is Liversidge v. Anderson, 1942. In that he said, in this country, amidst the clash of arms, the laws are not silent. And this case was later, overruled. And he talks about how the Supreme Court earlier used to not engage itself in overtly political cases, but then after World War II, there was another war that the United States was fighting in Korea. During that, the president of that time, Mr. Truman, had acquired some steel mills so that he could ensure that there is unhindered supply of goods made from steel, because the workers of that factory were they were protesting for wages, for more wages, because they were saying that we are overworking and we're not getting enough wages. So president acquired that property, and this case ultimately went to the Supreme Court. Even when the war was going on, the Supreme Court ruled that the president could not have done this. And this also shows about how the Supreme Court also changes its stance and learns from its mistakes. But it has to be kept in mind by the citizens that the Supreme Court can also make mistakes, but it is not because of any ill will uh, among the judges that they are making some partisan decisions. No, they are trying their best to make a good decision. Now, the another case is of Guantanamo Bay. Now, this is a very infamous island because of the torture that is, meted out to the prisoners of US wherever they are kept. And these cases went to the United States Supreme Court, and the Supreme Court ruled that the Congress, when it legislates that these people, these prisoners who are at this Guantanamo Bay, they have they have no right to approach courts for legal proceedings, that law is invalid and unconstitutional. So this is one of the other examples where it talks about how these emergency provisions like war or national security have not stopped courts from interfering and ensuring that there is a constitution and law that prevails, and not some ghost of national security. Then he talks about how even the president, who sometimes do not agree with the rulings of the Supreme Court, ensure that the rulings are enforced, because it is much more important to ensure that there is public acceptance, and the authority of the court is upheld. President George W. Bush, after this Guantanamo case was decided, he said, "We abide by the court's decision. That doesn't mean I have to agree with it." Um, in the part 3 of the book, in the chapter 3, the name of the chapter is called "The Check and the Future." Um, in this, he talks about how there are many institutions in the in the United States, but Supreme Court is one of those institutions that has more or less been able to maintain its authority over the people. So he gives a statistic. These statistics suggest that in 1985, 62% of the people believed in the institution of Supreme Court of America, whereas even in 2019 also 62% of the people believed in the authority of the United States. So to say that the people have some faith in the institution of the Supreme Court of America, whereas when it comes to the faith of people on federal government, which is say Trump administration or Biden administration, in 1958 it used to be 73% that people believed this government, the federal government, but in 2019 it dropped down to mere 19%. So now people have started to have so much suspicion of some institutions of the government, that he says that this is absolutely corrosive of the legitimacy of some institutions, and it is not good for the American democracy. And then he talks about how media is also depicting the court as absolutely partisan. He talks about how earlier sometimes it used to be mentioned that this judge has ruled this way and he has been appointed by this party, but now he says that the media goes out of its way and also always mentions that Justice Breyer was appointed by a Democratic president, Democratic Party president, but Justice Scalia was appointed by a Republican Party president. So he has ruled this way or that way. He says that this is one of the impressions that media makes upon the people, upon the citizens of the country, that really impacts the legitimacy of the institution of the United States Supreme Court. Then he talks about how a judge who is on the court is not a member of any party and does not support political ideologies, but he certainly has, or she certainly has, her predispositions. These are the convictions that they believe in. For example, somebody might be believing a little more in First Amendment, that this is the crucial amendment that sets the boundaries of government action and citizens' liberties. And somebody might believe that the government needs to be a little more welfareistic, or that Obamacare is a good policy, and somebody might believe that there is no business of the government in people's lives, so on and so forth, and that must impact the decision making of the judge. And also the fact that every judge comes from different background. A judge might have studied in a government school, another one in a very elite institution, somebody might have studied law at Stanford, somebody at Harvard, and somebody was an attorney first, somebody was working for the government first. So all of this impacts a person while they make a decision. Then he talks about these alignments that people often see, that mostly these five judges are on one side, another four judges are always on this side, somebody is this pack of judges, this bench of judges is always liberal, somebody is always conservative. He says that this really does not depend upon the party that has appointed them, but the fact that these are the judges whose whose judicial philosophies are like that. So always try to appoint a judge whose judicial philosophy matches theirs, so that they can ensure that the court does not hinder whatever they want to do. And he says that this judicial philosophy of a particular judge is seen as that judge being a politician who's only trying to push an agenda. Then he talks about how the Supreme Court of United States is an institution that evolves slowly. The evolution also happens slowly because of the fact that there are only 9 judges, and these are nine lifetime appointments, and these judges, stay on the bench for decades. For example, Justice Breyer has almost completed 28 years on the bench. He was appointed somewhere in 1994, I believe, and today is 2022, so 28 years as a judge on the Supreme Court. So there's not a lot that a judge might change. So when judges retire and new judges come in, even when they are from the same judicial philosophies, for example, now Justice Stephen Breyer will retire and he is considered to be a liberal judge. Now whoever will take the place of Justice Breyer would also be a liberal judge, because now Democratic party's president is governing the nation, and now he will certainly want to appoint a judge who aligns with his philosophy. So he says that the institution of the United States Supreme Court is very slowly evolving institution, and there's a lot of consistency that can be seen in the Supreme Court always. And more often than not, the change is always firstly seen in the majority of the society, and then that comes to the bench. He talks about how racial segregation certainly was ruled, is also a real example of where the bench first ruled something, and then it was slowly implemented by the Congress throughout the country, racial integration. And then he also talks about some things are really important that the bench takes the lead. For example, LGBT rights, or abortion. Abortion was legalized in Roe v. Wade, I believe, in 1973 or so. At that point, the country was highly divided, but it ruled in favor of the fundamental rights of the citizens. But he also talks about another issue, that was interracial weddings. Earlier in the United States, a black man and a white woman and a couple from different races could not marry. So there were so many times when, after the court had ruled in Brown v. Board of Education that racial integration has to happen, the court did not take on cases that were about interracial marriages, because it wanted to ensure that first step of racial integration in schools should happen, so that there is more public opinion and more public debate and discussion about should we allow interracial marriages or not. And then after around 13 years, the Supreme Court decided to take on a case. The case was called Loving v. Virginia, and in that it ruled that there has to be that whatever law there exists in the United States that prohibits interracial marriages has to go, because it is against the equality clause that is guaranteed by the by the US Constitution. Then he talks about how the present court is often seen as conservative. There are 6 conservatives on it and 3 liberals, but still in 2020, when there was all this Trump drama going on, wherein he said that the election has been stolen and these people have tried to steal the election. So he went to various courts. He went to the district level court also, and he went to the Supreme Court also. Even the district court, they said that no, we are not going to take this case because you are not providing with us with any credible evidence that something of this sort has happened, because it is a democratic process and we have faith in our institutions. Either you provide us with some evidence, otherwise we are not going to interfere with it. He also went to the Supreme Court, where he had at least 3 judges of that Supreme Court were appointed by him, and 6 of them were appointed by his own party. But the Supreme Court of United States refused to hear that case and issued only one line ruling that we are not going to interfere in this case. So he talks about how even when there was majority of conservatives, they did not do something that was to be illegitimate or illegal or unconstitutional just to favor a president of their party. Then he also talks about how even when there was conservative court, they upheld Obamacare, which was a welfare scheme that was implemented by Obama, and uh, which was, if they were all conservatives, they would not have allowed it. And then he talks about how abortion rights have been upheld. The precedent of Roe v. Wade has been upheld by this conservative majority, and immigration laws that were inhumane have been struck down, and path has been shown to the Congress to pass laws that are more humane. And then he talks about how the kind of changes that the judges of the Supreme Court themselves have to make to ensure that the authority of the Supreme Court is not in peril. He talks about 5 points. First point he talks about is that just do the job. Don't try to favor anyone, just do the job. Your job is to interpret. Please interpret as per your best wisdom. Do not try to ensure that you are going to get fame because you ruled this way or that way. Talks about don't consider popularity or support, criticism, or the likely reactions of business groups or labor groups or the media. He says that your loyalty has to be to the rule of law and not to any party. Then he talks, the second trait has to be clarity. He says that clarity convinces people that there is impartiality and truth in the court and they should follow whatever they say. He talks about also the kind of writing style that has to be incorporated into their habits by the judges. For example, if these are boring cases like bankruptcy court case, you can use more legal jargon, and you can make it a little more complex, so that because that only tax lawyers will be reading it. But when there is some case of constitutional importance, for example, say LGBT rights or abortion cases, then you have to make sure that you write an opinion which is widely accessible to the public, because the public wants to read what you have said. For example, if there is a decision on abortion rights and there are so many people who do not agree with you, and if they are not able to understand whatever you have said, then they will obviously believe that that you yourself had no conviction or clarity in your mind as to what you are saying. So clarity will convince people what you are saying is right and truthful and just. Then he talks about third thing about deliberation. So always there is, the Supreme Court of United States consists of 9 judges. There is always deliberation. There are always conferences before any decision is taken. He talks about how it happens. Before the deliberation takes place, every judge comes in with a point of view which is almost the way they are going to rule. But he says that the judges, most of them come with an open mind, so that they can change their view if they are presented with something more persuasive. And he says that the same attitude has to be employed by every judge, that they should make a point, that they should make up their minds about any case, but they should also ensure that if somebody is able to persuade them, then they should be able to change their mind, so that they should not look like fools when some stinking dissent makes more sense than the majority opinion. The fourth is about compromise. He says that most of the judges rule upon legal principles, and that is the reason that they can't compromise. But sometimes it is possible to compromise. For example, he says that for example, he takes an example of a case wherein there is a case that the government has said that the churches will be partially closed and partially open. So what will happen is that there will be religious activities will go on in a very limited manner inside the churches. For example, say the priests and some other people will be there inside the church, but the congregation that happens will have to be in the garden. So he says that, for example, if this case comes to the Supreme Court, the Supreme Court need not take very very divided view over it. So the Supreme Court can say that yes, there is this fundamental right which gives you First Amendment gives you right to practice your religion as you want. But there is another very serious issue at hand, that is the pandemic COVID-19. So this is a middle path you can take, and he talks about how sometimes you may be a believer that there has to be absolute religious freedom. If your conscience tells you that all right, this is a very temporary measure that has been taken, you can agree with the majority and go with it and not write a dissent. But if your conscience does not allow you, then you must write a dissent as well. He talks about how everything within that goes on within a judge and the ruling that the judge gives all depends upon what the judge's conscience says. If the judge's conscience is satisfied, then it is believed that he is right. He also talks about two cases. First case is called Pankingham versus North Carolina. This is almost the first case that the United States Supreme Court dealt that had a nexus between the criminal law and modern internet. This case was about a law that was passed by the legislature that said that if there is a person who has been convicted of sexual offenses, then they cannot go to a site where minors are also accessible. The Supreme Court said that this is an overbroad law and you cannot make it. But they did not, they also clarified that the legislature is free to make laws that are, in consistence with this judgment. So they can make laws that are more narrow, hit on the issue, and not bar a person completely from accessing their freedom. Then he talks about another case called Bond v. United States. Now this is a case of an extramarital affair. So there was a lady called Bond. She had a husband, and this husband had an affair. What Miss Bond did was that she applied some skin irritating chemical on the doorknob of this lady. Now this caused some irritation to this lady, and she sued her, and the criminal proceedings were also initiated against her, and the prosecution also prosecuted her based on the Chemical Weapons Convention. And this was obviously a very serious offense. Like, for example, this ultimately said that this is kind of a chemical attack upon the country. The Supreme Court ruled that this is not really the objective of this law. This is not a chemical attack upon the country, but a kind of an illegal act done by someone to seek revenge. So this should not be done. This is also something that he talks about, how the court can limit itself to very narrow things. For example, he says that if the court wanted to be divisive on this, the court could have ruled about how the president has the powers or not have the power, or the Congress has the power or does not have the power to enact treaties or enter into treaties or not. But what the court narrowly did was to rule upon, can this woman be charged with this convention or not. So he talks about how when such issues can come up where there can be a lot of divergence of views among the bench itself, then that can, if it can be avoided, then it should be avoided. But there are some cases that are of immense constitutional importance, and they cannot be treated in such way. For example, the constitutionality of one thing or the another when it has been directly challenged, for example. The fifth point that he talks about is that the judges should always be conscious of the broader perspective, that is that what the constitution really wants to say. that this country is an amalgam of so much diversity, and when we create such differing views in our minds and we write so many dissents, does it really help the country or not? He says that the judges should see the broader picture and should in no way be affected by their personal dispositions or predispositions or ideologies. Then he talks about what the people can do, the people who are outside the court, who are the normal citizens, who are not those 1 million of people who are judges or lawyers. He talks about how people must respect and try to respect the authority of the court, and also should try to believe that whatever the court does is in absolute good faith and they have no ill will to do something wrong to anyone. And that he says that the people should always be ready to believe that when there are split decisions, say 5-4 decisions, then there is always a possibility that some of these judges were wrong, and when they tilted the balance, the right decision went wrong. The right decision could not be taken. So even when the people are personally affected, they have to believe that whatever the court did was in their best personal interest. And if they believe that the court ruled it in a wrong way, then they can always initiate some legal proceedings to try to bring to the notice of the court as to why the court has ruled it wrongly, and the court will can always overrule those decisions of the court. Then he talks about the education that is imparted to the children. He talks about how there are just 24% of the children in the US who study civics as a subject at the age of 14. He laments that this is not good at all, because if you don't read civics, you don't know how the government works, and you don't understand the history of the institutions of the United States, and you don't understand the importance that they have within the polity of the nation. If you don't understand the kind of cases that the Supreme Court has decided, and the kind of faith that the people of the country has in the institutions of the country, then tomorrow when the Supreme Court rules something that you do not agree with, you are going to just trash it. You're going to say they do not know anything, I'm not going to follow it at all. So he says that civics should be taught, history should be taught, so that people can learn the lessons that the posterity has taught them. He also talks about these children should also try to become very responsible and also participate in the democratic framework. For example, say take part in protests if you do not agree with something. He does not say that take part in protests, but I'm just giving an example that take part in the democratic processes. Protest is certainly a part of democratic process. He also talks about how the only way the polarization can end in the United States, and today even in India there is a lot of polarized environment, it can only end when we learn to build consensus and compromise. And he talks about how there's another way to there's a way to compromise, that is to learn to try to listen to even the most opposite view that the person may have, in contrast to your view, and then ask them to elaborate it. When they elaborate it, you can always find something that you both believe in, and then you try to build upon that and reach a compromise. So this was my very long summary of this book. However, this book is just I think 60 pages or so. It is a short book, and I have read this book in one day, today itself, because and also I want to show you that now I will be posting more regularly. So this book, I found the third chapter to be a little more boring than the first two chapters, and also it's a very important book for everyone to read, especially when a lot of faith in the institutions is not left today. Today, even in India, so many people abuse the Supreme Court and other institutions, and I think it is a lesson for the Indian institutions as well, that if you don't try to ensure that you work impartially and independently, then people are going to trash you and question your credibility always. So it's an important, a very timely book that has been written by Justice Breyer. That's the reason that we all need to learn from the wisdom of Justice Breyer that he has tried to give to us. I don't think that you need to read this book after I have summarized it for you, because I have literally summarized everything that was there in the book. So thank you very much for watching. I'll be back very soon. You may consider subscribing to this channel, and if you are watching me on Instagram, please follow me. Thank you very much for watching.